Welcome to the Family Law Channel. I'm Scott Drake with my guest, Family Law Channel host Judge Eugene Hyman. We're doing an update on an interesting case. San Francisco's new sheriff is vowing to fight domestic violence and other misdemeanor charges the prosecutors allege are related to a New Year's Eve incident with his wife. He faces one count each of domestic violence battery, child endangerment, and dissuading a witness. And he's been booked, although he was released on $35,000 bond. There's been some new information that has come forth, and this is a fairly unusual case. I don't think you often have an elected sheriff a couple of days later being charged with a crime, and now he's in office, and this is fairly unusual. Judge Hyman, welcome back.
Thank you.
So let's talk about what new has happened, and that is an affidavit that has presented itself. Can you talk about that?
This particular case, there was lag time between when the incident occurred and when they were contacted by the neighbor. As a result, it's not committed in their presence or not within a reasonable time frame in terms of when it happened when they were contacted, and therefore they had to go the arrest warrant. The way the arrest warrant works is that a police officer makes a signed affidavit under penalty of perjury that certain facts are true. And this is given to a detached magistrate, in other words, a judge sitting as a magistrate. The judge reads the affidavit and then determines whether or not, based upon that affidavit, there's probable cause to believe, in this case, that a misdemeanor occurred and that the person accused committed certain crimes. So in this particular case, Judge Kramer read the affidavit and determined that there was probable cause to believe that these three crimes occurred.
Mm-hmm. And in this particular case, because this was covered by the media at great lengths as a newly elected sheriff, we're talking about the possibility of perhaps asking for a change of venue here, because the media has obviously informed everybody about what's going on here.
Right, and they could be alleging that as a result that the average juror has heard about the case and potentially has made up their mind. Now, in order to be able to successfully get a change of venue, that would require that they actually do some polling and that they have a research company call up a certain number of people randomly that might be prospective jurors and ask them a series of questions to find out about what they know and if they're in fact prejudging. But the first question that needs to be asked really is, from a tactical standpoint, is it in the sheriff's best interest to have his trial in San Francisco County or to have it someplace else? And in order to answer that question, you need to have a gut sense of are San Francisco juries more likely to convict people of domestic violence-related offenses? And in talking with people in San Francisco, there seems to be some concern that San Francisco County in general does not convict at the same rate for domestic violence that other Bay Area counties do. I don't independently know whether or not that's true or not, but that would be something that the defense would have to decide. Right now they're talking like they're concerned about unfavorable publicity and they might need to make that move.
Let's talk about the charges, because they're interesting here. I want you to kind of compare this case, because it is unusual to a typical domestic violence case. This is a misdemeanor charge here, but we have three charges. We have domestic violence battery, we have child endangerment, and dissuading a witness. And I think talking to you before, you said these aren't really that uncommon, but explain the child endangerment charge.
That's brought because the child is alleged to have been present when one of these criminal acts or the charged criminal act took place, and he therefore was very stressed, psychologically stressed by being present, and that supports that charge. The dissuading is that she indicates in the video that she's concerned that he has said in the past that he might take the child away from her, and that's obviously a very concerning thing. And also she has taken the position that these events didn't happen, and there's some other information in the affidavit suggesting that somehow he's attempting to influence her. Just simply saying to your partner or to the victim that if you testify against me, I'm going to be convicted, in and of itself is probably sufficient to certainly allege the charge. Whether a person would be convicted or not is totally up to a jury. But certainly there's enough information contained within the affidavit to suggest that he was trying to dissuade her from coming forward.
And also talk about because the wife or the victim did not call police, I don't believe. She gave the information to a neighbor who then called police. So again, it's sort of second hand here, and I think there were phone images that were taken at the time, and right now his wife seems to be supporting him. Does that have any bearing here on that?
Yeah, absolutely, because what she said on the neighbor's phone when it was taped would be hearsay. However, there are numerous exceptions in the evidence code in terms of when hearsay can be actually introduced in a trial. One of them is when you have a prior inconsistent statement. So if she were to testify that it didn't happen, etc., then this might be played and saying, well, isn't it true that when you met with your neighbor on January the 1st, you said these things, and you were crying, you were upset, and you said these things, and then in which case then she's going to have to say something similar to, yes, I did, but I made it up, or something of that nature. And then the other issue that's raised is prior bad acts. In other words, she says in the interview with the neighbor that this has happened before. So under California law and the majority of states in the United States, these prior bad acts can be admitted, not to that they would in of themselves prove the case, and a jury is cautioned during the instruction part of the case that they can't be the sole evidence to convict, but it can demonstrate modus operandi, it can demonstrate motive, it can demonstrate a lot of different things in addition to being used potentially for impeachment. And then the other important thing in terms of what she says is she's concerned about him claiming that she'll have the son taken away from her. So that's obviously a huge motivating factor in terms of her subsequent behavior. And if, in fact, the affidavit under penalty of perjury by the inspector says that this video says these things, and assuming that that's the case, that's obviously going to be extremely damaging evidence and going to be highly probative.
So finally, I guess in conclusion, say that he was convicted of all three. What would be the penalty here?
Well, technically, he could receive up to 1 year in the county jail for each offense, and under California law, the maximum time that you can do for any one time in terms of being sentenced to county jail is 3 years. There's no way that that's going to happen. San Francisco County doesn't use jail quite the same way that some of the other counties do, say, for example, San Bernardino, Kern, some of the more conservative counties. I wouldn't anticipate that he would receive a great deal of jail, but of course that also depends upon whether he enters a plea or whether he takes this case to trial and whether he testifies, whether it's somehow demonstrated hypothetically that he's been trying to influence her and things of that nature, in which case a judge hearing the case might decide that it's very serious and he should subsequently get a rather lengthy period of jail. In addition, he'd have to go to the 52-week domestic violence program. He would be ineligible to own a firearm for the rest of his life, and he'd have to pay certain fines and fees.
Mm-hmm. That sounds, again, problematic for his position as sheriff.
Oh, yeah. Well, he would potentially be in a situation where he could give someone a gun permit, but he himself could not possess a gun.
All right. Well, again, we thank you for your time and your perspective on this. It's an interesting case, unfortunate, but a very interesting case.
Yes.
All right. Thank you. And you're watching the Family Law Channel here on the Legal Broadcast Network.